Some people say that the German utility model is only a tiny patent. Well, this is absolutely wrong. Why? This I will tell you in the following video. In a lot of countries, a utility model is not even in existence. In Germany, we have such an intellectual property right. The special things about a utility model is that you can get it quite quick. So, for instance, if we file a utility model, then after 4 weeks or 5 weeks, we have already a certificate which shows that there is a utility model in existence. But this is not everything about this. So if you take, for instance, a patent, everything which is accessible to the public before the filing date is state-of-the-art. For a utility model, this is not valid. For instance, if you have shown your invention on a trade fair, then you will not get a patent anymore, because this was published before the filing date. But you can gain a utility model. So as long as this publication is not longer than 6 months ago, you can get a utility model and somebody else cannot destroy it. So the utility model is novel according your publication on the trade fair. This is one big example. Or, for instance, use in a foreign country is not relevant for a utility model. So a use, for instance, in Poland or in USA or Japan would destroy a patent. But the utility model does not care about this, because the use in a foreign country is not relevant. Then, oral expression of the invention, so for instance, broadcasting the invention or something like this, is not relevant. Only written statements are relevant, so publishing in, like in a book or something like this. So there are a lot of cases where we have a patent will not stay, or is not valid anymore, but the utility model does. So these are really big advantages. So you can get the utility model quite quick, yeah, and the state-of-the-art is different to the state-of-the-art of a patent. So if a patent is invalid, then a utility model can be still valid. This is really amazing. Well, there are also some drawbacks. Yeah, for instance, a utility model has only a duration of 10 years from the filing date. And you cannot gain protection for a method or for a procedure. But I think these are really minor problems. From my point of view, I prefer quite often to go to the judge with a utility model instead of a patent. And on the other side, it's more difficult if on the other side is a utility model which is against me. So this is really a powerful intellectual property right. And you should think about it if you want to use it. And the best is, yeah, you can have it parallel. So, for instance, if you have a European patent application or even a granted patent, and you have a parallel German utility model, then they can coexist. For instance, if the protection of the first is a little bit different to the others, then they can combine this. And the next big advantage is, as long as we have a patent application, does not care if it is a German patent application or a PCT application or a German patent application, we can separate a German utility model and can gain a really powerful intellectual property right. So, I hope this was interesting for you. Here you can find videos relating to the topic. Here you can find interesting videos, and here you can subscribe for the channel.